Hi, I'm Fraser Allen of ICLG.com. With me today are Ed Coulson and Rachel Ziegler of Bryan Cave Leighton Paisner. Ed is a partner who advises on complex competition litigation and regularly conducts multi-party litigation before the courts, and whose practice is focused on cartel damages actions, abuse of dominance claims, and other competition and regulatory disputes, regularly involving group claims. Rachel is a senior associate and deals with a wide range of general contractual and commercial disputes, including group claims. She has experience of all litigation stages, from pre-action through to trial and enforcement, and will be a partner in the firm from January 2022. Today, we're taking a look at the UK class action scene through the lens of key cases such as Merricks versus Mastercard, the growth of collective proceedings in the UK and their future prospects, and of course, the recent Supreme Court judgment in Lloyd versus Google. So, my first question for you today, Ed and Rachel, is what lessons have consumer cases like Merricks versus Mastercard and Lloyd versus Google taught us about collective actions in the UK?
Thanks, Fraser. Well, I think the clear lesson overall is that there obviously isn't a uniform approach to collective actions in the UK. And really the availability from a consumer point of view of collective redress really depends upon the cause of action that you have. And I think, Merricks on the one hand and Lloyd and Google on the other are really good contrasting cases to show that. And for Merricks, in the Competition Appeal Tribunal, where you've got a competition law infringement as the cause of action, it's clear that in the CAT, the Competition Appeal Tribunal, that it is prepared to take on the biggest of cases in its new collective action regime. And I think many were surprised that the first action in there was so big. It's a regime that's designed to be opt-in, and yet the CAT was happy to do an opt-out action. And I think some of the lessons that have come out of that judgment are that it's a much lower bar than people had anticipated for collective actions in the CAT, in the competition sphere. It's not going to be a merits test at certification stage as things stand. And another useful takeaway lesson from that was the courts have recognised the need for funders to get a commercial return out of those cases, acknowledging that some of the drivers or some of the key drivers behind those cases is the financial backing. And again, that was something that the courts needed to clarify, and they have done so. So certainly in the competition sphere, it's really developing now, but that's in contrast with other areas.
No, because as Ed alludes to, I think that you then take a different area of law, being the data privacy space, and we look at the Lloyd Google case, and actually the story couldn't be more different. It was only yesterday that we heard the Supreme Court has unanimously thrown that case out, has stated clearly that Mr. Lloyd's representative action should not be allowed to proceed. So I think that in the UK, are we going to see any more of these data breach cases? For the time being, it seems unlikely that they will kind of form part of the class action space going forward in the light of this judgment. And I think probably the significant difference there is that whereas with Merricks and Mastercard, Merricks, it was a competition claim, so he was able to bring his case on a statutory basis. What Mr. Lloyd was seeking to do was bring a representative action under the provisions of CPR 19.6. And the Supreme Court has basically held that is just simply not fit for purpose. You need to be able to satisfy the requirements of 19.6. You need to be able to look at the harm on an individualized basis. And a case like here, where you're talking about 4.4 million affected users, that's just clearly not going to be possible. And it was mainly for that reason I say that his claim failed. So as you can see, the cases actually and the sort of decisions of the courts really couldn't be more different. And I think that it's interesting as to sort of where things will go with the class action regime going forward. And I think it really does kind of depend, in what area your class action is.
Indeed. Now, following on from this, clearly these two cases have raised several very, very cogent issues. Are there any other unanswered questions about the UK collective actions regime? And can we expect answers anytime soon, do you think?
I think there are loads of unanswered questions still. It's very much still a fledgling regime. I think back in the competition and antitrust space, we've now had 3 cases have been certified and awarded collective proceedings orders. However, we still need to see how those cases run their course. And so all of the issues around how the cases will be tried, what evidence will be borne to bear, is all still to play out, really. And I think there's going to be lots of issues ahead. And thereafter, if and when there are judgments, how will distribution work within a class? How will unclaimed damages or surplus funds be distributed? So there's all those issues ahead, really. This is very much the beginning. And of course, that's in the cases themselves that have been certified. And again, I think there'll still be much more refinement of the law on certification in the first instance with future hearings to come. So I think it's in the competition space, clearly there's been a lot of movement, but loads of questions still to be argued about, I'd say.
Mm. And I'd pick up actually on a point I made earlier, this point about the difference between the Merricks and the Lloyd case. And, you know, a question I think many people are asking is the extent to which the government will move to put other areas on a statutory footing, as it has done with competition. You know, there is the question being asked already as to why the ability to obtain redress on a collective basis is only limited to a breach of competition law. And I think certainly for those lawyers and funders who are interested in the data privacy space, I wonder if there's now going to be quite a lot of pressure on the government to look to reform in that area.
Indeed. Now, are there any particular sectors from which we can expect to see further UK collective action?
I think certainly, and we've been talking so far in this interview only about competition and data privacy, but I think it's worth mentioning here environmental claims and environmental laws always being right for class actions, just the nature of the harm suffered. It's very suitable, and you know, a lot of the big environmental claims over the years have been done by way of group litigation and GLOs, which are group litigation orders. There was a case fairly recently called Vedanta, which was relating to harm in a Zambian mine. And that was particularly interesting, actually, because I think in that case, a group litigation order hadn't actually even been sought by the claimants, but was proactively ordered by the judge as just a useful tool to be able to manage this case more effectively. And I thought that that was a very useful indication as to sort of the courts here are becoming kind of increasingly au fait with the concept of group litigation and happy to grapple with the complexities of it. The other area which I think is worth keeping an eye on is in the securities space. The Woodford Fund scandal, which is the fund that collapsed, trapping 300,000, I think, investors and billions worth of savings. We're starting now to see the first of those claims hitting the courts, and they'll of course be looking for claimants to add to their groups. So I think that's another space to keep an eye on in the coming months ahead.
Excellent. Now, bearing in mind that we have all these various sectors that are emerging now. We have the financial services, we have the environmental, and we also have the consumer class actions. How big do you expect the UK collective actions market to become? What kind of potential do you think is there?
Yeah, it's a good question. I think definitely there's going to be a lot of long-term growth for sure, and these cases are going to grow year in, year out. I think it's going to be a long way off anything like approaching the sort of class action system that there is in the US, for example, to take an easy contrast. I think it's unlikely, in fact, that it'll ever become like that in this jurisdiction. However, there is going to be significant growth, but that growth is patchy, as we've talked about. I think if you look at the competition sphere, I think that is going to, class actions in that space is really going to change the landscape. I think looking ahead, you're really very likely to have collective actions in relation to many competition law infringements. And I think that really is going to change the landscape of how that area proceeds. By contrast, of course, we talked about data again, and perhaps there's a real halt there for the moment in that space. And meanwhile, incremental growth in securities and environment. So it's definitely growing. I don't think it's going to be an overnight rapid expansion, but that growth will remain patchy, I think.
Thank you. Well, I think you and your colleagues have your work cut out for you for the next few years in this sector, that's for sure. But thank you very much for taking the time to join us today, Ed and Rachel. This has been a very interesting insight into collective actions in the UK. I think it will be of great interest to colleagues from other parts of the world, especially at such an interesting time for collective actions in the UK. I'm looking forward to seeing you both at the Global Class Actions Symposium in London next week, November 16th, 17th. So see you there.
Thanks, Fraser.
Thank you.